How old are you?
37.
You're 37. I don't understand going to a bar and people tell you to leave. And your answer to people telling you to leave is, I'm going back to my vehicle and I'm getting a gun and firing the gun. I don't understand that. So I don't know if he wants to be under oath to explain that to the court, but this is what I'm trying to wrap my head around. I don't understand why people's first answer to any situation is, let me go get my gun.
Well,
And I know people, I don't know, people seem to have a love affair with weapons. And if you want to have a love affair with the weapon, then you need to treat the weapon with respect, because the weapon can kill if it's in the wrong hands. And I'm just trying to figure out, there's an incident that happens. Somebody calls you out your name. Oh, let me go get my gun. I'll show you who I am. Somebody tells you to leave a bar because, I don't know, maybe you're intoxicated. Maybe there's some altercation. I don't understand why people don't leave.
I would say that the offense report and PSI reflect that he says he had had 5 beers and 3 shots. So I would submit to the court that he was not thinking.
Yeah, I mean,
He
to
was-
me,
And I'm not saying that intoxication is a defense or mitigating at all. I'm just saying that, it causes a loss of impulse control. And
I mean, I understand what you're saying, counsel, but sometimes I think alcohol gives people courage to do what they otherwise wouldn't have done, as opposed to, oh, my inhibitions are released. Yeah. So I don't know if he wants to speak to the court or not, because I'll tell you, I'm leaning towards sending you to prison. I haven't heard anything that would suggest to me that I shouldn't send you to prison, because I don't know somebody who takes some shots. I realize you were intoxicated. I'm reading it, but people put you out of the bar. And it's on Mother's Day too.
It was 6 guys that took me out.
Yeah,
So
because you wouldn't leave. When people tell you to leave an establishment, just leave. So I don't understand why I should give him deferred adjudication when he went to a bar. And according to things he's saying, somebody tried to come on to his fiance. That's when you leave. And they told him to leave. And maybe they were very rough and pushing him out of the bar. I will give you that. They were rough. They bruise you up, maybe push you out of the bar. But that's where you leave and go home. Hopefully you were not driving with those tequila shots. And then, or if you don't want to leave and you stay in the parking lot, you call the police, but you don't tell people, well, I'm going to show you who I am. And then you go to your vehicle and get your gun. Did your fiance say any, did his fiance say, hey, what are you doing? This is crazy. Let's just go home. Okay.
The altercation at the bar wasn't good. I think that there were probably others there who also had weapons. Again, not to say that there's necessarily a defensive or mitigate, but maybe it's a little mitigating. It just turned out to be a very rough circumstance. I'm not making light of the offense because obviously it's serious. And I think that the PSI speaks to the alcohol being an issue and intensive outpatient. So I think if the court would give him some opportunity to address the alcohol and maybe perhaps anger management issues, maybe that would help to lessen his future risk to the
And I
community.
see that there are other people who had guns, because I see Eric Fields, who's one of the complainants, not the main complainant. He says, I just want my gun back.
Yeah.
This is Texas. We just want our gun back.
So ma'am, I haven't been in trouble since 2005. And being at that
You want to
bar,
raise your right hand to be sworn in? Can you, do you solemnly swear and affirm that the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand, state your name for the record.
Guadalupe Gutierrez,
And let me just tell you, your statement about you haven't been in trouble since what time?
2005.
I haven't been in trouble since 1969, and I'm putting it at 1969 because I was potty trained by then. And I didn't pick up any criminal cases. I always tell people when they tell me I haven't been in a gang. I don't do drugs. I haven't been in trouble. It's like, do you want a cookie for that? That's what you're supposed to do. So let's not start with, I haven't been in trouble since this date, because I'm looking at your criminal history and one of them is terroristic threat. And then criminal trespass. And is this criminal trespass with a weapon?
That was with a box cutter at my aunt's bar. I just left work.
Okay. And then the theft of a vehicle.
That was back in '04.
And now we're back here.
Yes,
And on on the probation from 2013 on the criminal trespass with a weapon, your probation had to be extended. Then on the theft case, a motion to revoke was filed and you were sent to TDC. And now you have this that started as an aggravated assault with a deadly weapon, and the state reduced it to a deadly conduct 3rd degree. So speak to me. Why should I give you deferred? I don't understand why I should.
well, I mean, I'm not a good talker, but.
That's
you
okay.
told me not to say how to start it, but
No,
I
go.
was trying to prove a point that since 2005, I haven't been in trouble. You know, and all those years I was in the oil field for 15 years and I've never had my daughter. So now that I got my daughter, it's a blessing to me because I always wanted it. So now I have an opportunity to be a father and I don't want to mess that up.
I mean, but you have.
I understand.
I think the reunification, if you will, sort of took place after this offense. Is that correct? Meanwhile, you've been on probation with your daughter.
Yeah, I mean, it's been good. It's just like I've been on the monitor and I can't blame nobody else but me. But I just started, it gets me kind of angry because I can't take my daughter out other than be with her in the living room.
Well, I don't know why you angry about that. That's all on you.
That's what I just said.
If you would not go to a bar drinking to the point of intoxication and you're in your 30s, you're not a teenager who doesn't know better.
Yeah.
I think that if the court would give him an opportunity for some form of treatment, I think he would welcome that and appreciate that opportunity.
I just don't think he's a good candidate for probation. I mean, shooting up a bar. And it wasn't.
It was outside in the
Mhm.
parking lot.
I see that. Hold on. Thank you. And State, I know you're silent.
Yes, Judge.
Is our applications for probation, for community supervision and deferred?
Yes.
I don't know if it makes a difference to the court. I don't think it necessarily does, but we can withdraw the deferred.
Now, see, this is what I'm reading, and this is my problem. I can understand people being angry and getting upset with people. I honestly don't ever understand people pulling a weapon, because I always taught if you're going to pull a gun on somebody, you need to know that you're to kill somebody, and don't pull a gun unless you're going to use it. That's what I was always taught. But what it says here in the police report that you stipulated to, I contacted Jason, who is the manager and point of contact for surveillance. Jason provided me with footage from one of the cameras. Jason said he was working on getting footage from the other cameras as well. The footage showed Guadalupe, that's you, being taken out of the bar. He walks to his car and pulls out a small handgun. Guadalupe pointed the gun in the air where 4 spent shell casings were found. Guadalupe and Melissa got into the vehicle and he pulls up to the curb. Eric can be seen in the corner near a white car. Guadalupe opens the car door and his hand extends out. Guadalupe then lowers his hand with the gun and points it toward Eric.
I never pointed the gun at anybody.
I mean, that's
else
what they
but
say is on the
her.
video. I mean, this is video. This is not,
And I showed her that when I saw the video, I pointed it.
Well, because it's surveillance, some parts of it are a little clearer than others, but as the car drives out, it's a little bit less clear because of the angle of the camera.
okay. All right. Is there anything else from either side?
Nothing from the state, Judge.
No, Your Honor.
All right. How old is your daughter?
7.
Okay. All right, this is what the court is going to do. The court is going to find you guilty, sentence you to 3 years in the prison, give you credit for any time served. There's to be no contact with Eric Fields and Lefty's Draft House. Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, and because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, good luck to you. I did take into consideration that you have a child and that you want to be in her life and do better, but you're going to have to start making better decisions. And it's obvious that you can't drink.
In the last 10 minutes, we watched this case swing from hope to consequence. The defense leaned on steady work, clean GPS, and a 7-year-old waiting at home. But every time, the judge came back to the same story. A crowded bar, too much alcohol, and a gun fired after he refused to leave. 3 years in prison means he'll still see his daughter grow up. But from behind razor wire, do you think she struck the right balance between mercy and safety? Comment below, and remember to like and subscribe.
Herrera for the state.
Defense.
Sorry, Sean Sheffer for defendant, Your Honor.
And are you Mr. Duran?
Yes.
Counsel, have you received all the discovery and did you review it with your client?
Yes, sir.
Court will find that the state is in compliance with discovery. Mr. Duran, I'm showing you what's entitled Application for Deferred Adjudication or Community Service. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Showing you what's entitled court's admonishments and defendants waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with injury to a child, bodily injury intentionally or knowingly? That's a 3rd-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? You need to speak up.
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to 10 years in prison and up to a $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He had, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, sir.
Mr. Duran, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial, showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state recommends deferred adjudication. There's an affirmative finding of family violence. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, ma'am.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, ma'am.
Did you understand that to be the entirety of your plea bargain agreement?
Yes, ma'am.
Defense,
Yes, sir.
state?
Yes, Your Honor.
Showing you the paragraph entitled waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Next, I'm showing you outside the plea bargain agreement. State is requesting that you deferred adjudication be for a term of 3 years. There be the BIPP course, no harmful or injurious contact with Michael Duran. Did you understand those are recommendations by the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
State offer states exhibit 1 and all attachments.
No objection.
Showing you what's entitled waiving consent to stipulation of testimony and stipulations. Did you review this with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything that you wish to say on behalf of your client?
Yes, Your Honor. As you've I'm sure read, this is a case, it's a little older, over a year old, Judge. During that time, he has worked with CPS. The child was never removed from his custody. Child did very well with him. He did everything required. They ended up closing the case. It was not a legal case, Your Honor. He is just requesting, he understands he did wrong, that shouldn't have happened. And he's actually also already started a family violence class also, Your Honor. So we're just requesting the court to follow this recommendation.
So were you the CPS attorney?
No, that was not. He, like I said, Your Honor, there was actually never a legal case, Your Honor.
Okay. Anything you have to say for yourself?
Yes, I was, that day I was disciplining my child like a parent should. He acts dramatic and he was trying to, I understand what I did, but I'm trying to.
Yeah, you're trying to shift the burden on him.
Explain.
I don't believe he's trying to do that, Your Honor, because we had discussions. He understands
Well, he's
he went
saying
way
his
too
child was
far.
asking-
He went way too far. It shouldn't
He's-
have happened.
He's saying that his child acts dramatic. That's what he said. Dinah, could you, did he say that? Excuse me?
He did, Your Honor.
So he hasn't learned anything.
I disagree with that, Your Honor. Having
Well,
known him for
What have you
this
learned?
time.
I learned how to talk to my child. I'm always being there for him. He's always coming for me to advise. He gives me this random, I love you, I hug you. I'm always.
No.
Um,
Here's my thing. You told me that he was acting dramatic. You told me, and if the record is not clear, or if I'm remembering things incorrectly, please correct me. But you told me that 1, your child is dramatic, and 2, you started by saying, I was disciplining my child as a parent should. That's what you told me. So how does disciplining a child as a parent should result in a child having a belt mark on their face? And was that being dramatic? Because that's what it says in the police report, that he had a belt mark on his face, belt mark on his arm. And how old was your child at this time? What, 9, 8, something like that?
yes, ma'am.
So basically, what you have taught your child is that your child needs to fear you. which means that if your child accidentally sprays something in somebody's food, he can't tell you because he knows what's going to end up happening. He's going to get hit with a belt across his face. And I don't know why people think disciplining children equals, let me pull out a belt, let me beat you with the belt, because this wasn't let me tap you with corrections. And now you get an attitude with me. And let me just tell you, I will send you quick, fast, and in a hurry as a condition of your probation to the Bexar County Jail or either to the state jail facility. And you can see how your discipline works with other people at the jail if it comes to that. So I'm telling you, when you beat a child, this wasn't discipline, this was a beating. When you beat a child, what they learn is to fear you. And you are a grown man hitting on a child. If somebody, let's say, for example, you're at somebody's house. They invite you over, you're sitting at the table and you drop your food on the ground or on the carpet, and it's white carpet, and they get angry. And so they take a belt and slap you across the face. And they tell you, well, I'm just disciplining you because you knew this is white carpet. You know, I told you to be careful not to spill anything on my carpet, and you did. You know what you would do? You would call the police and you would file charges because that person hit you. So you've gone beyond disciplining your child. And I don't know why people don't understand that. And you can say your child out of the blue is saying, I love you and all of this. Sometimes, you know why they're doing that? Because they're walking on eggshells. Because you have put fear into this child. If this child were to pick up a criminal case, you know what they'd come to court and tell me? His attorney would? He suffered trauma. Well, what trauma did he suffer? Well, his father beat him. They're not going to come in and tell me the father disciplined them. They're going to come in and tell me my father beat me. And that's what this was.
It wasn't like that, Judge.
Did he have a belt mark across his face?
I can't recall. I don't remember. I remember him just ducking, and usually
Just ducking.
usually I try to punish him, send him to his ground him, take away his video games because he does wrong. He understands that.
So why did you beat him with a belt across his face? Is it because the girlfriend came to you and said, this is what happened?
No, that wasn't the case at all.
Yeah. So why did you beat him?
It was just he was acting up during the day, and it was
Doing what?
well prior to that we had went swimming. He had jumped in the deep end, and I told him don't do that. So I went after him, and then when we got out, he kept on picking on his sister and my daughter. My daughter's like, Dad, he keeps on messing with me, keeps on pushing me, acting like he's gonna push me into the water. So we go out to get food.
Who's your daughter's mother?
The same mother.
Who's the same mother?
Yes, ma'am.
Okay. Finish your story.
And so my daughter is like getting irritated, and I'm just like, calm down, because he has ADHD. And so we get home and we finally sit down for dinner, we say our prayers and everything. And he decided to get some Lysol and disinfect her burger because it was during COVID. And so he was just acting up. I sent him to his room. He goes and slams the door, and I'm like, behave. My daughter comes back crying, that he had done something to her toy box, and said, son, what's wrong with you? And he was just very quiet. I said, well, tell me what happened. Just quiet. And so I didn't mean to hit him as hard. I didn't mean to hit him at all, but I was trying to tell him, like, you need to calm down, you need to behave already, you need to, stop messing with your sister. Don't go trying to push her into the deep end. He already went into the deep end and kind of sort of drowned, but I was able to, save him. So I wasn't trying to target him. I was trying to make him understand that it's not okay for you to continue acting like this.
And what have you learned from your parenting classes? Because I'm assuming CPS gave you parenting classes.
No, it's voluntary.
Did you do parenting classes?
Yes, ma'am.
Who did you do parenting classes?
It was compadre.
Okay.
So,
I like compadre.
and I learned a lot.
What did you learn?
I learned how to calm myself down, don't explode. Take a deep breath, wait a little bit, talk to him, settle him down, right? Try to understand where he went wrong, where we both can try to understand each other. He is very active, he's very compulsive, and that's part of the ADHD that he has from his family, from his mother's side. My daughter is just like me. We're very chill, we're very calm, and he just
See, you keep saying, so the daughter has the same mother as your son?
yes.
Okay, and where is the mother in all of this?
She hasn't been active. She had never been present in such a life. I took custody of them when my daughter was out the hospital because she was born with methamphetamine in her system. My baby mama was a drug addict, so
Mother, your children.
yes,
All right, are you employed?
yes, ma'am.
What do you do?
I do renovation and remodeling, demolition work as well.
All right, this is what the court is going to do. 4 years deferred adjudication. There's an affirmative finding of family violence, proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. I'm going to give you 200 hours of community service restitution if you provide your certificate or proof that you completed the compadre parenting course. Then I will deem that the community service hours are satisfied.
Thank you, Judge.
There's to be regular reporting by Zoom or in person, regular UAs, field visits, random, one time a month for 3 months. Then if all is going well with the field visits, then we will decrease it to one time every 3 months random. And that will stay in place until further notice. There's to be no harmful or injurious contact with Michael Duran. And probation, is there some, I don't think this is a BIPP issue. This is more a family issue. Is there some type of family counseling that can be?
Donna, I'll look into, I can look into it. And, yeah, I can look into it.
Your Honor, he has also started a class, so maybe you can give that to them and see if that would work.
Yes. So I just don't think this is a BIPP course situation. This is more family dynamic situation. All right, probation. Is there anything else he needs? Is there anything else you need from the court to be successful?
No.
All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go out the record. Good luck to you. You're gonna have to do better.
Thank you.
And you're gonna have a lot to make up to with your son, because believe it or not, I know you say things are better, yes, but your son is always gonna remember that. So you're gonna have to make it up to him and let him know.
He saw me get arrested in March and he's like, Dad, I didn't mean to get you in trouble. And he's like, Dad, every time the cops come, he's like, are you gonna go to jail?
Yeah.
I don't want him to be thinking that.
No, but see, you gotta turn that around and not let him make it his fault, because him saying that is him saying it's my fault, and it's not. Okay?
30 minutes into this docket, the focus shifts from guns in a parking lot to belt marks on a child's face. The new father on the stand calls it discipline, blames ADHD, and even says his son is just being dramatic. The judge isn't buying it. She calls it what it looks like, a beating that teaches fear, not respect. Now, probation, parenting classes, and strict conditions stand between him and prison. Would you call this discipline or abuse if you were in that courtroom? Comment your verdict and remember to like and subscribe.
To the state, Your Honor?
Defense,
Arnulfo Ortiz for Mr. Henderson.
are you Mr. Henderson?
Yes, ma'am.
All right. Counsel, have you received all the discovery? Did you review it with your client?
Yeah.
Court will find that the state is in compliance with discovery. Mr. Henderson, I'm showing you what's entitled application for probation. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We waive.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Both counts?
Yes, Your Honor.
Let me look here. Indictment as presented.
No, Judge, can we, the state waives and abandons counts.
Any objection?
No objection.
All right. Mr. Henderson, I'm showing you what's entitled court admonishments. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're being charged with theft of a, well, motorcycle, but vehicle, 2,500 to 30,000 as a state jail felony? Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
I understand.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Henderson, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on count one only. Punishment is to be assessed at 2 years in the state jail facility. There's a $500 fine. The state is opposing your application for deferred adjudication. They're recommending community supervision. There's to be restitution to Brennan, BRENNEN, Perkins, and this cause number, the theft course, and the MRT course. Did you understand that to be the plea?
I do, ma'am.
Defense,
Yes, Your Honor.
state?
Yes, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places?
I did, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
Not by me. He had filed one on his own.
Outside the agreement, the state is requesting that your community supervision be for a term of 4 years. There be a TAP evaluation, 200 hours of community service restitution, and no contact with Brennan Perkins. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
I do, ma'am.
Then to the offenses charged in count one, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
Your Honor, I submit States Exhibit 1 and the attachments.
No objection.
Showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that with your attorney? Did you understand it? Did you sign it? And all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the All right, after reviewing state's exhibits one and attachments, the court will find there's sufficient evidence to find you guilty. Are we proceeding with sentencing?
Yes, Your Honor, we requested we follow the prosecution's recommendation.
All right, so you're not asking for deferred adjudication?
We are not.
All right. All right, Mr. Henderson, are you employed?
Yes.
What do you do?
I work in the oil field on a drilling rig. We would ask that he be allowed to travel outside, although he will reside in Bear County.
All right, do you have any children?
I do,
What are their ages?
17 and 16.
And do they live with you or with their mom?
They live with their mother.
Okay.
I get custody of them when they're not in school.
Okay.
However you want to put that.
All right, you've been to prison before?
No, ma'am.
Jail before?
I've been to jail.
All right, for what?
Petty theft and DUI.
All right, and what's up with these tattoos?
Bunch of stuff when I was younger, just I've grown out of it all.
All right, what's with the arm that's covered in the black ink?
Yeah, that's a whole bunch of cover-ups.
Who did that cover up?
I had a friend of mine do
That-
that.
That
It's
was
horrible.
That's not from the ink show. When they do a cover up on the ink show, they do a great cover up.
Yeah, again, like I said, it once upon a time type of thing. I've grown out of all that.
And what's the tattoo on this side?
It's just a bunch of like Greek mythology stuff. Again, younger.
Oh, well, who is that supposed to be? I can't tell.
The Mary Magdalene.
She's not a part of Greek mythology, is she?
Well,
I don't think she is.
No. But the rest of it is just,
Okay.
like I said, I was a lot younger and a lot dumber.
It's not his fault. He's from Indiana.
Wow.
All right.
We got watermelons too.
Okay. Well, hopefully they're sweeter than what's at the HEB. You know, I'll be the stereotypical Black person. I love watermelon, especially if it's sweet. This season hasn't been that good, though, Robert Porter. It's been hit or miss. All right. This is what the court is going to do. The court will find you guilty. The court will sentence you to 2 years in the state jail facility, suspended and probated for 4 years, 200 hours of community service restitution, probation. Since he's going to be working in the all fields, if he wants to pay that off at $7.25 per hour to the San Antonio Food Bank or some other charity that the court would approve of, you can do that as opposed to the community service hours.
Okay.
The theft course, the MRT course. There's to be regular reporting by Zoom or in person, regular UAs, or you can do the patch. And usually a patch doesn't work in all fields, but probation can go over that with you. There's to be no contact and restitution, if any, to Brennan Perkins. And we'll do field visits 1 time per month, probation, and you can just check to see how things are at the home and make that one visit a random visit. And if you think he needs more, then you all can do it as needed. Proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. And probation, if he's working in the all fields, then he's allowed to work in the all fields. Probation is, does he need anything else? Do you need anything else from the court to be successful?
No.
Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All All right, we can go off the record. The MRT course is supposed to teach you how to do what's right.
That's moral recognition therapy.
Yes,
Yeah,
but you
I've
should,
heard of it.
you should know the difference between right and wrong. How old are you?
I'm 39.
It's time to stop the foolishness. Otherwise, you're going to find yourself in somebody's prison, be it Indiana or Texas or wherever. People don't.
After 40 minutes of pleas, lectures, and hard truths, a pattern is clear in this courtroom. Guns in parking lots, belts across a child's face, stolen property, and the same judge trying to decide who gets treatment, who gets probation, and who goes to prison. Some walk out with one more chance, others leave in handcuffs, hoping to come back better than they arrived. Watching this docket, do you think justice was firm but fair or too harsh on these defendants? Share your thoughts, and don't forget to like, subscribe, and stay tuned for more real courtroom stories.